That is the hello, with regard to item number 44 and 45. The hearing very on behalf of the other. Taken the consent of the other side. Paying for an adjournment, man.
Yes, after answering, both sides are represented. On the prayer made by Mr. Andas, counsel for the appellant, list after answering vacation, winter vacation.
Can it be after my 15th of February? 15th of February.
February is so long.
Or my lord,
He's just saying that you make
first week of February, my lord. After 2nd February. Any date, madam. Third, fourth, fifth.
list for hearing the week commencing 5/2/2024. Okay.
I would like
You'll have to just wait for 2 minutes. Seniors to you, they are standing, correct? Just 2 minutes.
Item number 4 may be adjourned and listed after vacation.
2018 matter.
The program is there and available to appear. Any date may be fixed.
4.
Any date may be.
You've taken consent of the other side?
Yes.
Okay. With consent of the other side, Mr. B. Hussain, counsel for the petitioner, place for adjournment, prayer is allowed after ensuing vacation. List after ensuing vacation. Yes.
Thank you, Lord. What you are taking item number 50, my lord. 50. Mr. Samari is
50.
Yes.
Okay, after vacation is prayed for by counsel for the petitioner. Okay. But this 50, have you taken steps?
Steps have been taken, my lord. Service is deemed to be complete. The matter was listed before the Laosma court, my lord. The order
Oh,
is
achha.
there.
Okay.
So, Lordship, Lordship can kindly
As
tell-
matter is, as it is submitted by the learned counsel for the petitioner, that case is ready regard service. List the matter in the admission column. Interim order extended.
I'm obliged.
Okay.
The consent of the petitioner, so I'd like to mention item number 58, supplementary list. Okay, adjourn for the day. Okay, will come after.
58. Okay, list after. You've taken consent?
Yes.
Okay. With consent of the other side, Mr. A. Borwa, counsel for the respondent, place for adjournment, praise the Lord. List after ensuing vacation, winter vacation.
Okay.
Any interim order is operating? Yes.
It's a private to mention item number 56, Lordship. For adjournment for the day, Lordship. I have taken consent from other thing. 36.
36. Your name?
Yes, sir.
Yeah, on the prayer made by Mr. A.K. Azad, counsel for the applicant. With consent of other side, the matter stands adjourned today.
Perfect.
List after ensuing winter vacation. Yes. Now, yes.
Thank you, Mr. Lordship. I would like to mention item number 7 and 8 for adjournment. We have taken consent from the other side, my lord.
7 and 8. Okay, you're taking consent of the other side?
Interim may kindly be extended. Interim may kindly be
Okay. You're for?
Petitioner.
No, she's for?
From the response.
For the respondent, okay. Both sides are represented on the prayer made by and counsel for the respondent. Matter stands, list the matter after ensuing vacation. Interim order passed today stands extended to the next date of listing. Okay. Yes.
Yeah, please, Lordship. I beg to mention item number 33. Lordship, steps are yet to be completed. As per office note dated 13/12/23, unserved notice or AD card has not been returned. Corresponding number 1 and 2. So
Okay.
I may be allowed to take fresh steps.
Okay. As service report on the respondent is awaited, The petitioner shall take fresh steps for service of notice on the respondents by registered postal lady,
And the street. Lordship.
postal uh, um, postal receipt number, track report, list on so and so.
Also, Lordship, there was a small correction that is to be made, a typographical error, and that may be allowed to be made by hand, Lordship.
What is the nature of correction?
First, it is as per section 150. Application under Article 227 of the Constitution of India, read with section 151, it should be 115, Lordship.
No, we can't allow. Both 227 and 115 can't go together. Correct. But then you have to make a submission and then tell us why these two can travel on the same boat. Correct. On the next date, you tell us. Be prepared on that point
After interview.
after winter vacation.
Obliged.
No, you have to give it after 4 weeks. Service report, huh? After 4 weeks.
Eight visual lordship.
Ah.
You got to item number 14, my lord.
Yes.
Respondent, my lord. Item number 14, my lord. So it may come after vacation, my lord. My senior has some personal difficulties.
Okay. You have appeared in the matter. You filed your Vakalatama.
Yes, our Vakalatama remained in the IA year.
Acha.
There was a delay confirmation petition that was allowed.
Okay. Both sides are represented. Mr. A. Dattal, on counsel for the respondent, has submitted that his Vakalatama is on record in the
Correct.
records of IA Civil.
Treat 5 million. 2000.
It was hello condemnation
I'll check.
confusion. 3353
5/10 of 2021.
21.
Yeah.
Records hello.
I'll check.
The record so and so, which was an application for condonation of delay, and he for accordingly, the registry shall examine the same and reflect the name of the counsel for the respondents whose names appear in the record of the said condonation application. While listing the matter next. On the next para, on the prayer made by Mr. V.K. Barwa, counsel for the appellant. Matter stands adjourned today, list after ensuing winter vacation.
Item number 14.
My lord, similar prayer, my lord. Item number 48, my lord.
I'm for the respondent in that.
48. Okay. Both sides are represented. On the prayer made by Mr. V.K. Barwa, counsel for the petition matter stands adjourned today, list after ensuing vacation. Interim order is there.
Lord, last page, it was not executed. Super comfort admission.
Okay, as matter is ready regards service, this is the matter in the admission column. Immediately after the ensuing winter vacation. Right, only once, not twice. Okay, 48.
May I please alert?
Yes,
With the consent of others, I beg to mention item number 16, your lordship. I'm praying for adjournment, lordship. Matter may be after vacation.
16. You have taken consent of the other side?
Yes, sir.
Okay. Both sides are represented. On the prayer made by Mr.
Yeah, sir.
A.R. Das.
Yeah.
On behalf of
Asipal, sir.
the appellant, matter stands adjourned today. List after ensuing vacation. Why it has come for orders?
Lordship, the respondent number 3 has expired, lordship. We need to substitute respondent number 3.
Okay, it is noticed that the respondent number 3 has expired. It's only that. List after ensuing vacation. Okay.
Much obliged.
May I please, Your Lordship? Lordship, I wish to mention listing of an regular first appeal, Lordship, on 11th of January. The urgency. 11th.
Give it to the court master.
Top of the list, item 50.
11th of January, it will not come. And make it 12th or 12th will be just before vacation. Make it 10th, not 11th. 11th is a hearing day.
I need mathematics pass over for the time being.
Item 1,
No, item top of the list, item
Oh, acha.
55.
item 55. Just a moment. Okay, after some time. Item 1
Yeah, trigger.
is an appeal. It's an appeal.
On the 29.
You are the probate petitioner, the respondent. You are the petitioner. Okay. Mr. A. Biswas, counsel for the appellant. This appeal under section 299 of the Succession Act is directed against the judgment and order dated 15/9/2023, passed by the learned judgment and decree dated 15/9/2023, passed. No, in this probate suit, will it be a decree? It will still not be a decree.
There is, but decree has been passed.
Decree has been made up. Okay. Judgment and decree dated 15/9/2023, passed by the learned district judge, Kamrup Metro Guwahati in,
Not metro.
but you have written in the cost title Guwahati.
It is, it has been error. It would be Kamrup
Kamrup Amingaon, okay, Kamrup Amingaon in PTS
2 of.
number 2 of 2018. By which the probate petition was dismissed, right?
Yes.
Appeal is admitted for hearing, call for the records, issue notice returnable on so and so. Applicants, after 6 weeks give a date, the appellant shall take steps within 2 days for service of notice on the respondents by the registered post with AD as well as by usual process. Next, the learned counsel for the petitioner is at liberty to collect the postal receipt number and submit postal track report prior to the next date of listing.
Are they of that?
Item 2. Yes, Mr. Sharma.
Telling the order of the trial court matter, it was 23. Here, whatever by this court's order matter, they 27/5/2016.
Just shows the previous order and the impugn order.
Next, E matter page 11.
Page 11.
Here, what happened, I am the landlady manor, a widow, running her basis for rent, she collects. And this defendant, respondent here, manor, was a tenant since 1991. There was agreement initially for 7 years, rent was 800. Then in 99, we didn't want to give him because my eldest son was to settle. He was unemployed. But he insisted that he would raise the rent and agreed to raise the rent to 1200. Rent receipt was issued with 1200. In his manner, after point, what he did, he corrected it to 1000. There I have an extension. Then manner decree was passed in both the courts manner, the concurrent decree. The outside came to this court. Individual. And the plea taken was manner that the rent receipt has to be examined by expert. On that basis manner, the matter was remanded. Of course, while remanding manner, the judgment and decree were set aside. It could have been mannered remanded on the basis of examining those documents. And I think that's what. And while remanding on, there was one mistake manner that both inner foil and outer foil and inner foil had to be examined, only outer foil was given. Then, my lord, election with the input order, my lord. Page 24. In my inner foil minor, which is in my position minor, there is, it's all right, 1200. And the different is also put the signature there in the outer foil. But in the outer foil is manipulated. It was not sent to handwriting expert minor, the minister did not send it, and he said it is all right. Page 26. Well, should be examined by handwriting expert.
You have a copy of your petition which was rejected?
Three zero five zero.
305. Because Mr. Sharma, apparently we don't find any reason to interfere because the order of the High Court is very clear.
Page 26. Actually, how handwriting is to be examined? Can your lordship, I examine it, but just looking at it. Your lordship finally come to,
No. You see, the order of 3/10/2023. It says that the High Court has ordered only the outer counterfoil to be seen, and therefore it was Exhibit E, not Exhibit F. Exhibit F is the inner counterfoil. So inner counterfoil is rejected,
of course, let.
and it does not say. It says that you give evidence.
It is, the handwriting has to examine, that is the order of this court. Your lordship finally come to page 28, your lordship will be clear. This is the outer foil. This is the outer foil. See your lordship. 1200 is written. And in words also, 1200 taka, patro. And in the manner left hand side, you corrected 1000.
No, you see, the trial court has not said that we will not call for the expert's report. It says that you lead evidence. You see, when the plaintiff is called upon to lead evidence or defendant is called upon to lead evidence,
Right, in the application manner, it is here. My prayer was to send it to the handwriting expert. court on which their eyes matter cannot be examined in that thing. And there is also my submission is enter submission notice matter in the paragraph 24 and 25. Page 24 and 25. Page 24 also can be. My submission is with me. Quoted application. And what the court finding was in page 25 manner, there is no scope to send the matter to the entire expert. Now do you determine whose entire whose? Court is sent for examination. You exercise its jurisdiction. Jurisdiction means the court always known to send. One by prayer is there. Person coming from police layer or wherever it is, put the court of this.
Which is the outer counterfile? It is 1, 1, 1, 2, 1, 3, or it is F, F1 and F2, F2. Which are the outer counterfiles?
Outer count one. That also matter.
No, which one is that?
Outer count of one is the receipt I give it to the
Which is one? It is exhibit 1 or exhibit F? Which is the outer counterfile?
exhibit E. Is the outer count.
Then your petition is rightly rejected. Not because you are now making a prayer to to send the for forensic examination exhibit 1 and exhibit F.
Let us forget it now. Because this code director.
No, Mr. Sharma, it can't be forgotten. You see, what is under challenge is the application, which is a rejection order of the petition number 50 or 303, whatever, 20305. So we have to go by this application and the order. Now you are modifying the order saying that I want to adduce evidence for exhibit E. E is never a subject matter of this petition. So I can't adjudicate that.
Court remanded on.
No, I don't know. You see, I don't know. It is not there. You please look at it. It is not there.
E112, because he also might come to high court order. F is the.
I don't know. Look at the petition. It's not there. I can't allow you to build up a case here.
So exhibit one means my exhibit, he is defendant exhibit one.
You see, I'll have to understand because this is not there. It's not come anywhere.
But then exhibit and my.
No, then you file copies of the evidence because I don't know. Is not here narrated here that exhibit E is exhibit 1. Same thing.
Just this one, it is here. Photocopy, page 28.
28.
You also exhibited. Exhibit A is also exhibited.
This is exhibit F.
Yes.
It's not E.
Okay, E I will put this.
Yes.
Then next, just next page. Oh.
No, produce a copy. It will be better because if I am not very sure.
Yes.
And I'll tell you, since Mr. Sharma, you and Mr. Sahil are there, I take the liberty of telling what has transpired in the court today, yesterday. It may lead to me changing my character. You see, in a proceeding, there is a matrimonial proceeding. Another bench of this court, knowing that both are counsel, ask them to come to chamber and then have a in-camera proceeding. You see, in family dispute in-camera proceeding and even in this, this proceeding, I'm interacting with you, correct? I'm asking you questions. I'm saying that I'm not satisfied. So what was done was, whatever happened in the chamber was transcribed in a petition and said that it should be made a part of record. So yesterday a question arose that if I'm compelled to do that, it takes away the independence of the judiciary. I can't speak my mouth. If I say something, then somebody will come and say that, please write it down in the order sheet. You see, that I am not satisfied. If I write in the order sheet, you are prejudiced. So normally what will I do is that I record the statement, I adjourn it, correct? So everything which transpires in a matrimonial proceeding in the court is not recorded. And application was filed to make it a part of record. Name of the honorable judges are quoted. What happened in the proceedings was quoted. People who were present, their names were written as if an evidence is being created. So therefore a question arose that if I keep my mouth shut, if I don't interact with the lawyers will not even understand why their petitions are being rejected and dismissed. Today I am interacting, I'm giving you an opportunity. Mr. Sharma, because we know, I have been there. At times we miss some things. So therefore, yes, so therefore,
Because judges really speak, so we do not know how to interact.
no, that's why I'm saying, if I am reacting, it's not because I'm an adversarial party to the litigation. I'm asking to elicit information and to ask questions, to interact with you so that you get an opportunity. But if something like yesterday happens again, I have to keep my mouth shut.
No,
No.
that was, I think, both of them were lawyers.
Both of them are lawyers.
Oh, that was-
Where is the difficulty? Even yesterday, I asked them to be in the chamber, discuss the matters, how to resolve it. But it was, you see, it is just intuition that I allowed one of my staff to be in the chamber. Because somebody may accuse me of anything because at times I express my mind without thinking what the consequence would be of my utterances. I make some statement. And matrimonial proceeding, advocates are there, both sides. I ask them to be, one of the staff to be there. But the question is not that. The interaction, what I'm saying to you is that if I stop interactions, because I'm disturbed since yesterday, if I stop interactions, what would happen? It would affect not only the lawyers, the best of the lawyers here, but it would also affect young juniors who are aspiring to be good lawyers. They can open the mind, at least in my court. They can speak something. But if I stop that, the juniors will never get an opportunity of interacting in the courtroom.
And one more thing is there, when your lords interacts with us, many times what we do, then we immediately improve our case. Because
No, that is why
your lordship meant that they were lordship negative, going in the negative way. So we improve our mind, improve the case and.
No, that is why we have learned, because I was also there where you are standing. I know if the honorable judge asks me questions, then I have a chance of giving a reply. I can speak out, I can improve, I can add something, I can pray for an adjournment, produce documents which are not there. So since yesterday I am disturbed, in fact, that if this happens, and if I am to what you call, weigh everything before I speak to both sides, will it be in the good of the institution, or it will not be good? So since yesterday I am in trouble. It is affecting. No, Mr. No, I'm speaking out to you just to vent out my, because you see, this happened yesterday. Whom should I say? My wife will not understand what is happening. Correct. So those things, in my house, nobody will understand. I can't speak to my courtmaster, and then these people, they also can't help me. So I'm in fact narrating this to seek your help. So what you call this?
Better, my lord, that
Because at times, yes, we don't understand. You are making a submission, you are the owner of the brief, you know what is there. I may not be able to understand in one go what is the matter about. A young lawyer may, you are very articulate lawyers, senior lawyers, knowing the subject, you may make the best point first. And somebody else, maybe the counsel assisting you, if they are to argue, maybe the best point will come at the last. So if I don't give them an opportunity of making their submission, how will they grow? They are the future. So since yesterday I'm a bit disturbed. Well, it affects the independence of the judiciary. If I ask questions, if you say that no, make it a part of record, then I ask the question. You see, in a civil suit, let us say in a village there is a land dispute. The other side comes and tells before the Gaumbura and the ladies who are there to settle the matter. They say that no, okay, I leave 3 feet land. Correct. But when it comes to court, can somebody make a memo of that and say that no, in 2012, he said that he will leave to 3 feet of land and therefore make it a part of record? Can we create evidence like that? No, I'm adjourning it. I'm just saying it because I have to. This is a way of venting out my what you call mind so that I can cool down.
Coincidentally, after the end of this matter, Mr. Sayan is on the other side, was on the other side. Huh? In this case, you are the other side.
Okay,
In this matter, please.
in this matter.
Yeah.
Okay, you just give the documents
I'll give you.
on the prayer made by Mr. R.P. Sharma, Senior Counsel, assisted by Ms.
Yeah, Dekar.
A. Deka, counsel for the petitioner. Prays for leave to file additional document by way of an affidavit. There is allowed. List after ensuing vacation, winter vacation. Mr. Sharma, please make a mention if it is not listed, because all matters are now being deferred after vacation. So we are not fixing a date. Make a mention. Item 3.
Signed by the state, you said, the original suit should have been cited. On the basis, even if they're finding against me, there was original suit. Because both the judgments are set aside by.
Let's set aside. I understand.
On this point only,
Ah.
not on merit.
Ah,
So the original suit will revive and the
correct,
public.
correct,
That I will have.
correct. Just remind me out on the next date.
Yes.
Yes. Time being, okay. 56.
And control better manner where I am the tenant. I in the trial court, I have an application for calling for the NJ cases melody, deposit of rent. Prayer was rejected. Then I filed an appeal. In the appeal also, we have taken the grounds matter. So far, the rejection order is concerned. Then the.
Order 41 to 27 was rejected.
No. But here, my lord, we filed the petition in the trial court. Trial court rejected it. Then when it appealed, my lord, we have taken the grounds that rejection was wrong, my lord. Now what happened, my lord, at the ultimate stage, the respondent side filed a written argument. We were directed to argue the matter. We filed the application saying that we have applied for certified copy of the NJ cases. Some time may be granted to us so that we can file those NJ cases copies. Now the trial court, what happened, my lord? He said that it's not necessary. But we can also see that order, disciplinary order, my lord, page 86.
Yes.
Appellant by filing has paid for adjournment showing the ground appellant wants to an application, file an application so and so in order to bring on record certain documents, more especially NJ cases record for proper defense. Hard both sides produced so and so. It advised for a case recorded on 16/1/23. Respondent has submitted the written argument and the same was furnished to appellant. And on the same date, the due adjournment application filed by the appellant, the matter was adjourned for further arguments.
Oh,
Now
no.
the appellant
Okay, I've got it. We'll stay this. Mr. G. N. Savala, Senior Counsel, assisted by Mr. P. Deka, Counsel for the petitioner. Next para. the uh, by this application under Article 227 of the Constitution of India, the petitioner has assailed the order dated 15/12/2023 passed by the learned civil judge within bracket senior division bracket close number 1 Kamrup Metro Guwahati in TA number 6 of 2023, by which petition number 8288 of 2023, which was filed under order 41 rule 27. No,
Adjournment, my lord.
Acha, for adjournment was rejected. But you do not file 4127.
Wait for certificate copy, my lord, apply for certificate copy, we say that we shall file those copies, my lord.
It's not been given.
Not been furnished, my lord, till now. If you also see the application, my lord, at page 84. Is the application, my lord.
By which petition number 8 to 888 of 2023 seeking adjournment was rejected. Next, madam. Issue notice returnable on so and so after 6 weeks give a date. The petition shall take steps within 2 days for service of notice on the respondents by registered post with AD. Next, madam. The learned senior counsel for the petitioner has prayed for stay of the proceedings. So it was urged that in the dispute between the parties is a landlord-tenant dispute, and in the and before the trial court, what had happened in the trial court?
The prayer, my lord, for calling for the NJ cases
Acha.
was rejected.
The prayer for calling of the NJ case records, miss with the bracket NJ, bracket close, records was rejected. Full stop. The suit was decreed against the petitioners. It is one petitioner or more?
One.
When the petitioner. And thereafter, appeal, a regular first appeal was filed before the learned lower appellate court. Full stop. In the full stop, by the said petition number 8 288 of 2023, the petitioner sought for adjournment on the ground that he has applied for certain certified copies of certain NJ case records and desired to produce the same before the learned first appellate court. However, the learned trial court, and it is pointed out that the learned trial court, while adjudicating the prayer for adjournment, entered into the merit of the projection of the petitioner about the requirement of producing the record of NJ cases. And it is submitted that they said observations may prejudicially affect them. Affect the petitioner at the trial. Which page was that order?
Well, page 86, my lord.
86.
Let that become final. I'll go so.
So it is also submitted that in the said petition, the petitioner has expressed his intention to file an application under order 41/27. But the learned trial court preempted by rejecting the prayer for adjournment, preempted the petitioner from making such application. Next paragraph. Having regard to the nature of submissions made by the learned senior counsel for the petitioner and on perusal of the record, the court finds that the learned trial court, first appellate court had made certain observations on merit of the application which is not even filed. First of, in that view of the matter, the court is inclined to stay for the proceedings of title appeal number
6 of 20.
6 of 2023, pending before the Court of Learned Civil Judge, within bracket Senior Division, bracket close number 1, Kamru Metro Guwahati, till further orders. We'll say till the next returnable day, till the next date of listing. List on so and so. Take steps within 2 days. 57. Oh, okay. Oh, yes.
Can it be listed tomorrow also before?
Oh, okay. List this matter before any other bench without me. Mr. B. Chakravarti, counsel for the appellant. Sorry, petitioner expresses that there's some urgency in the matter. Full stop. Okay. Right.
Item স্যার কালিতে দিলে অসুবিধা নাপাব তেওঁলোকে।
মানে first, according to the registry, shall make an endeavor to list this matter before any other bench without me at 2 p.m. today. Because tomorrow I'm not bothering anyone. Even I may not like to work hard tomorrow. So try to see, he'll try to speak to the registrar.
List.
5. Yes.
This matter is filed against the order dated 22/11/17 and 8/2/19 of the trial court. Here in this matter, what happened, Lordship, this petitioner is a housing cooperative society. The petitioner entered with an agreement with a respondent, defendant number 1 to 8, who intend to sell their ancestral property, your lordships. And as per that agreement, your lordships, the petitioner purchased schedule deal and your lordship. And so far the schedule B land is concerned, they are disturbing the possession of the petitioner.
You see, your
What
application
happened in
cannot be
this
allowed.
matter,
Mr. Dasgupta,
Yes, Lordship.
your application cannot be allowed. You have prayed for under order 6/17.
Lordship.
That can't be allowed. You can't by amendment induct parties. There are some other provisions in the CPC. You can't do it like that, because if you can't file a suit against a dead person,
Lordship,
so if the dead person is already a party,
Lordship,
you can delete it,
it
no
is-
doubt.
Yes,
But this application would be misconceived, not under Order 6 to 17. It may be under any other provision, but not under Order 6 to 17.
while filing this suit before the trial court, Lordship, it is not in the knowledge of the
I
petitioner.
understand, but you see, by amendment, you can't introduce parties. If you want to induct certain parties as array somebody as
That may be a bona
plaintiff
fide
or
mistake.
defendant.
That may be a bona
No,
fide
no, but
mistake,
Order 6 to 17 is not the appropriate provision.
Lordship. That is,
There are several judgments of the Supreme Court. There is a order authored also by me, where I've explained this concept. Introduction of parties, what you call addition of parties, cannot be under Order 6 to 17. That can't happen.
so a liberty may be granted, Lordship. Otherwise, there will be no proper execution of the suit, Lordship. It is because on getting the information, immediately I filed the petition, Lordship.
Dasgupta, I can't do anything. In fact, I will not be able to touch this application. You see, respondent number 5 is a dead person. Can I issue a notice against a dead person? Notice was not issued. Now, can I pass an order without hearing a party to the application? And I can't hear this because even I am afraid of ghosts.
Lordship,
I can't issue a notice on a dead person,
No.
ask a ghost to welcome a ghost, and then say that please argue before me. I'm very afraid.
that was the situation, Lordship.
And like those English movies, I don't have that
Maybe
what you
given
call
maybe
a sign
given
of God
chance
with me.
So
I
that we can implement the legal error, Lordship. That was mistaken, the mistake.
No,
done
I
by the-
understand, but you see, in English movies, we understand there is a silver bullet. There is something called figures of God, which saves us. I don't have those. So if there's a dead person in the record, I can't pass an order. You better have it deleted, so we'll dispose it off. Just say on the prayer made by Mr. S. Dasgupta, counsel for the petitioner, the name of deceased respondent number 5 is struck off. Next para, as per order dated 19/10/2022, service on the remaining, service on the uh, 19/10/22, service on the other remaining respondents. Is accepted to be complete. Oh, sorry, make it 5 and 8, both deceased. Huh? 5 and 8. Next paragraph. By filing this application under Article 227 of the Constitution of India, the petitioner has assailed the order dated 22/11/2017 and 8/2/2019, passed by the learned civil judge within bracket senior division bracket close at Sivsagar, thereby dismissing Ms. J case number 130 of 2017 and Ms. J case number 145 of 2017. First stop. Next paragraph. By Ms. J case number 130 of 2017, prayer was made under Order 6 Rule 17 CPC, read with Section 151 CPC, to amend the plaint, proposing to
Delete, Your Worship.
delete the names of respondent numbers 5 and 8 and to implead their legal representatives. First one, the said petition being rejected by order dated 22/11/2017,
The same day, Your Worship.
the petitioner filed a review petition under Order 47 Rule 1 CPC, which was registered as Ms. J case number 145 of 2017, whereby prayer was made to review the order dated 22/11/2017. Next, the learned counsel for the petitioner has submitted that when the suit was filed, the petitioner plaintiff was unaware that the respondent numbers, that the defendant numbers 5 and 8 had expired. And therefore, the prayer for amendment of the plaint was made. Next paragraph. Having considered the circumstances under which this application under Order 6 Rule 17, read with Section 151 CPC, being Ms. J case number 130 of 2017, was filed, the court is of the considered opinion that that by way of an amendment of the plaint, parties to the proceedings cannot be struck off or added. Full stop. There are next part, the petitioner shall be well advised of the legal provisions by virtue of which parties can be added or struck off. Full stop. In the event an appropriate application is filed, the learned civil judge within bracket senior division bracket closed Sivsagar shall consider the same and pass appropriate orders in accordance with law. And the impugn orders dated 22/11/2017 in Misji case number 130 of 2017 and order dated
8/2.
8/2/2020. Sorry, what is the date? 2019,
19 lordship.
8/2/2019.
In Mistake case number
Passed by
145.
the said learned court in Misji case number 145 of 2017 shall not come in the way of adjudication of the appropriate application filed by the petitioners. Petitioner. There are other provisions. You'll have to apply under that.
Lordship.
Parties can't be amended. There are judgments of Supreme Court as well as one authored by me.
I'll check it, lordship.
I think Mrs. Chaudhary will be able to tell you. There's one was passed in her case. Impleading of parties. One of, I think I passed one order in your case. It was on Kabristan matter. I don't know. That was 4 years back. I won't remember. That was an order, I think, in 2019. 18, 19, I won't remember that much. That lady was there. One shop. No, not that matter. There was a shop which was sought to be demolished. Not that. You're not there.
Right, lordship. I'll check it, lordship.
There is an impleading application because Kabristan I remember. And there was you were also the one. Parties had died, impleading application.
This application I have to file there within, is there any time? lordship?
I have not said anything. Ms. Bharat, that this the interim order passed earlier, staying the proceeding of the suit stands vacated.
Highly obliged.
Close it.
Dismissed. Dismissed with liberty as
Dispose.
indicated above.
That should be disposed.
No, this is dismissed, but with liberty as granted.
lordship.
Item 6.
All the time. As in there is a next. Lordship.
You see, Mrs. Chaudhary, you'll remember, I don't know, I am recollecting you. You see, there was a property defendant, there was an order, somebody, it was ex parte against someone, the legal heirs came asking to be impleaded. That impleading application was disallowed. And I remember passing an order allowing the impleading under the yes. But I don't know if I am remembering you as the counsel. Huh? No, I may be wrong because it was 3-4 years back. It's not a recent order. Yes.
Lordship, Senior Counsel Mr. D. Mazumdar is appearing in the matter. Lordship, since it was not a fixed matter today and he is out of station today, Lordship may kindly accommodate a date right after vacations, Lordship.
Both sides are represented on the prayer made by learned counsel for the respondent. The matter stands adjourned today. Interim order passed earlier stands extended until stands extended till further orders. List after ensuing winter vacation.
Much obliged.
Item 9.
Okay, time being. Then just a moment. Yes, who is appearing in the matter for respondents?
Look.
You are the only one.
Look.
There is no private respondent here.
Sorry, Lord, here is private. Two private respondents here.
Okay, you are appearing for both.
I'm appearing for state law.
Is state a party here?
Lord. Respondent number 8, 9, 10.
Oh,
I
acha,
was-
acha. Okay,
I was-
okay. Where is this impugn order? Which page?
Page 15.
We'll have to allow this application. We'll have to allow this application. The implementing has to be done.
It's correct, Lordship, but which was the matter which was pending in the before the municipal court, Lordship. The birth certificate and death certificate are actually facts. You have instruction, got instruction from the control. Yes, I am taking.
Suite is also not maintainable. Suite is also not maintainable. In view of the section 28, one of the registration of birth and death.
I am not deciding rejection of plaint. This is also ground to allow it. Because the applicant claims to be the daughter of Roy Ali. So Roy Ali's daughter will be a necessary party in such an application.
Lordship. Here's another thing, Lordship. The name of the husband of the petitioner. It is mismatched, Lordship, which was petition filed by the petitioner Abdul Karim and others in the lower court, Lordship. The third party petitioner Leela Begum, wife of Mustan Ali. And this is the where the plane in the plane, Lordship. It was mentioned as Abdul Motlib, Lordship.
Name of
No, Lordship, it is correct. Sorry, Lordship. It's another. Yes, sorry.
name of the applicant is Laila Begum.
Leela Begum.
Leela Begum, wife of Mastan Ali.
Mustan.
Where is your petition? Page number?
Page number 32.
32.
32. It is correct. You are not a person, Lordship. Abdul Motlib is a husband of
Okay,
the
okay. No matter. Doesn't matter. For Mr. K. Uddin, counsel for the petitioner. Also heard
Here,
Mr. T.R. Gogoi Leonard,
government.
government advocate appearing for the
Number 5,
5, 8, 9 and 10.
8, 9, 10. 5, 8 and 9. 8, 9, and 10.
9 and 10. You're also appearing? No, F8, 9 and 10. Uh, uh, There are total 10 respondents in this matter. None, no other respondent has entered appearance. And they are unrepresented when the matter is called. Next, the as per the office note, dated 16/8/2023, and order dated 22/11/2023, it appears that the notices on all the respondents have been duly served. Next para. The petitioner herein claims that on her complaint, the birth certificates of whose birth certificates? Okay. Birth certificates of respondent numbers 1 and 2 had been cancelled by the competent authorities after due inquiry. On certain anomalies being noticed in the issuance of such of the said two birth certificates. Full stop. Aggrieved by the action of the competent authorities in cancellation of birth certificates, the respondent numbers 1 and 2 had instituted TS number 214 of 2022 in the Court of Learned Munsif number 3, Karimganj. Inter alia, praying for declaration that the birth certificates of the plaintiffs were genuine and that the cancellation of birth certificates by the Registrar of Births and Deaths, Karimganj Municipal Board was illegal, arbitrary, and beyond the norms and procedures, and for other reliefs. Good stop. In course of the said, in course of proceedings of the said suit, the petitioner, on whose complaint the cancellation process is projected to be initiated, approached before the learned trial court with an application under Order 1 Rule 10 within bracket 2 CPC, Order 1 Rule 10(2), read with Section 151 CPC for implement in the suit as well as the connected Miss J cases. Wherein she claims to be the daughter of late Rois, ROIS Ali, and Suron, SURON BB. asserting that the respondent numbers 1 and 2 were not the children of her parents. Full stop. No objection was filed. So it is projected by the learned counsel for the petitioner has submitted that the principal respondent numbers 1 and 2 did not file any written objection. Full stop. However, the learned trial court by the order dated 21/1/2023 rejected the said prayer on the ground that the object of order 1 rule 10 within bracket 2 CPC was to enable the court, at any stage of the suit, to add a person as a party to adjudicate upon and settle all the questions in the suit, and accordingly arrived at a conclusion that when impleading of a third party would mean de novo trial, a third party shall not be impleaded. Full stop. The learned trial court had also expressed its opinion that where the impleadment of a person would change the complex of the litigation, his or her presence is neither necessary for decision of the question involved in the proceedings, nor to enable the court effectively and completely to adjudicate upon and settle the question involved in the case. Accordingly, the petitioner was not considered to be a necessary party, not necessary or proper party in the suit, and accordingly the petition was dismissed. Full stop. Next, the learned government advocate has submitted that the stand of the government is not adversarial, but he has produced the not but full stop. Nonetheless, he has produced the parawise comments which he has received, which from the parawise comments, which is dated 15/6/2023, issued by the Deputy Commissioner Karimganj, it appears that on inquiry about the birth certificates issued to the petitioners, respondent numbers 1 and 2, namely Abdul Karim and Piara Piyara Begum, it was found that the same was not genuine. And the relevant documents in support of such contention are also found, have also been forwarded. Full stop. We stop at that and do not desire to make any comments which may which may prejudice any party to this proceeding. Next paragraph. It appears that the learned trial court, while deciding the petition for impediment, which was registered as Misje case number 440 of 2022, the said learned court had failed to consider the provisions of section 50 of the Evidence Act, 1872, which is reproduced below. From the above, it appears that when a court is required to form an opinion as to the relationship of one person to another, the opinion expressed by any person who is a member of the family, has special means of knowledge on the subject and therefore, relevant. Next paragraph. When in this case, the petitioner has approached the learned trial court and has expressed that she is the daughter of late Rois Ali, R-O-I-S, Ali, whose parentage is claimed by the principal respondent numbers 1 and 2. Where is that birth certificate? Which page is that birth certificate? 42 is the one which is cancelled.
No, my birth certificate. 42 and 43.
No, which is the birth certificate which is cancelled?
This was the birth.
This is the birth certificate.
This was cancelled by the
Okay.
order at page 42.
Whose parentage is claimed by the principal respondent numbers 1 and 2, the court is of the unhesitant view and opinion that the petitioner herein, who claims to be the daughter of Muhammad Rois Ali and Srimati Suron, S-U, what is the spelling? S-U-R-A-N, Suren BB, would definitely be a proper and necessary party when it comes to adjudication on the relationship of the respondent numbers 1 and 2, who also claim to be the son and daughter of her own parents. Next paragraph. It is inconceivable that by way of a decree, someone can be allowed to become children of a particular parent, even without participation by other sons and daughters of the same parent. It would amount to creation of a relationship which is alleged by the petitioner to not exist. Next paragraph. for the reasons which are assigned herein before, comma, the court is of the considered opinion that in litigation where the existence of relationship between the respondent numbers 1 and 2 and the parents of the petitioner is involved, comma, the petitioner is definitely a proper and are both proper and a necessary party, and without her presence, a suit ought not to proceed. Full stop. Accordingly, moreover, comma, in the event the court finds that the matter, the court is inclined to remand the matter before the learned trial court for a fresh decision on the application filed by the petitioner under Order 1 Rule 10(2), comma, the court further expresses that in the event the court, the learned trial court, after adjudication still finds that the don't say the first of all, accordingly, the court is inclined to hold that the impugn order dated 21/1/2023 is not sustainable on facts and in law, as it was passed without considering the issue of relevancy as provided for in Section 50 of the Evidence Act, comma, 1872, full stop. Resultantly, comma, the proceedings of Media case number 440 of 2020 stands restored to the file of the learned Court of Civil Judge within bracket Junior Division, bracket clause number 3, Karimganj. Full stop. Next paragraph. The said learned court shall hear the matter afresh and decide the said miss case in present afresh. So, however, the said learned court shall not be influenced by the observations, comma, if any, made in this order. Therefore, the court also is also inclined to hold that the impugn order dated 21/1/2023 suffers from jurisdictional error, for which is not found sustainable. The same at the next paragraph. The petitioner was represented by his learned counsel, her learned counsel shall appear before the learned trial court on 22/1/2024, and by producing a certified copy of the order, comma, wait for further instructions of the said learned court. The learned government advocate shall provide a copy of the parawise comments to be kept as a part of record. After that, you give it. It will be the parawise comments.
Right.
Item 11. what is the illegality?
Questions relate to lordship. The statutory provision for considering the percentage of sort of wages is 60% in all injury cases. It isn't taken as 80%. But that's a statutory consideration. And the other is lordship, it's a implication between the wrist and the forearm. That where there is
Heard
60%.
Mr. R. Goswami, learned counsel for the appellant. By filing this appeal under Section 30 of the Employees Compensation Act, 1923, the appellant has assailed the judgment and order dated, judgment and award dated 9/10/2023, passed by the Commissioner, Employees Compensation, Golaghat, in EC case number 3 of 2022. The appeal is admitted on the following substantial questions of law. It will only B will cover it. I think A and B is almost similar.
Yes, the same. One is wages, the other is lordship.
Other is
One is the wages. Wages is lordship in the injury cases taken as 60%, in death cases is taken as 50%.
yes.
Because it has been taken as 80%. Out of 12,000, it was considered 12,000, it makes it, having 60% of 12,000.
Then A and B, page 6. Then A and B both.
Can be,
Okay. Let the records be called for. Next, the appellant shall take steps within 2 days for service of notice on the respondents by registered postal AD. Next one, the postal receipt number, postal track report. We have issue notice returnable on after 6 weeks, 9/2/2020. As a stay application will be a separate stay. That's or operation of the impugned judgment and award date remain state subject to deposit of 50%.
it's 21 lakhs, I mean 10 lakhs. 10 lakhs, it comes to 21 lakhs.
50% of the awarded sum before the registry of the court within a period of 6 weeks. It is made clear that if the deposit is not made within the time allowed, this order shall not be a bar for enforcement of the award insofar as 50% of the award, 50% of the award is concerned. Notice here also. Here also you have to take notice in the IA. Item 12. Just a moment. Just a moment. It's only quantum of questions. 50% you can deposit. Okay. MSCT case. 50% awarded. Same 6 weeks.
Yes.
Allow, admit, and then issue notice.
Problem.
Yes. In this code, if there are bail matters, you tell us, we'll upgrade and take it up. We don't want to keep you waiting. In the morning, just tell where is the other side? Item number 13.
The judgment has already been pronounced.
Already been pronounced. It's become infectious. Mr.
Yeah.
A. Ali, counsel for the petitioner, as well as Mr. K.K. Das, learned APP for the state. Next, para. The learned counsel for both sides have submitted that during the pendency of this bail application, the trial court has decided the decided, had given its final decision in the trial of NDPS case number 5 of 2023. Next slide. In view of such submission, it appears that this bail application has been rendered infructuous. Accordingly, this on having been rendered infructuous, this application stands closed. What has happened? Acquittal. Acquittal. I could understand. Because this is a course you should follow. You will understand, because this led to me to do certain administrative side, we took up the matters. In this case, if you just for your interest and upgradation of your lawyering skills, you go to the trial court, look at the record, you will understand what I am trying to say. There are reasons for me to tell you. And this is also something which I've last time also discussed when I had expressed my mind that as public prosecutors, we should do some in-house, introspection on these matters. Because these drugs are something which have a tendency to affect everyone. Because society is affected. It may not affect me, but as I'm a member of the society, it affects these drugs. So in this is a case where you should have the introspection. Yes.
15. Item 15.
There is no representation by the appellant. It is also noticed that this matter has not yet been admitted. Mr. For Angel Justice, the matter stands adjourned today. This after ensuing winter vacation.
Seventeen.
There is no representation of the applicant. For Angel Justice, the matter stands adjourned today. List after ensuing winter vacation. Yes, next matter, item 18, 19.
18 and 19.
I am paying for SPNO 1, 2, 3, and 4 lordship. As per office note dated 11, 12, 2023, LCR has been received. And service is already completed.
We'll go for hearing.
Yes.
Okay, none appears in call for the appellant. However, Mr. P. Borua, learned counsel for the respondent, 1 to 3 and 4 submits that the case is ready as regards service and LCR is received. Next, accordingly, lists the matter for hearing in the month of February 2024. You are the plaintiff or defendant? Okay, it's okay. Item 20.
Service. When respondents, performer respondent is yet to be completed. Let the matter. Take a step again. First step.
No, for that, I'll have to pass specific order. This when you are doing a shortcut, we'll also do a shortcut. We say the learned counsel for the Mr. V.K. Bhagwati, learned counsel for the appellant, shall take note of the contents of 2011-2023 office note dated 2011-2023 and take appropriate steps.
For the respondent number 1 and 0.
Okay, Miss
Miss
S.
Siddhika.
Siddhika.
On behalf of S. Ali.
Okay, you write your spelling, otherwise I may make a mistake. Siddhika, the counsel for respondent number 1 and 2 is present. Again, before that you also write, and accordingly you can take notice of the same and take fresh steps for service of notice on the
Number 4 to 19.
on the concerned respondents.
Five, 6,
Okay.
9, 12, 13, 18, and 19.
May you go through it because I've asked you to go through it not for nothing. You have to go through it, otherwise
This I have noted it down. I have noted down.
you have noted it. Then it's okay.
Lots.
I'll take a break and come back. Because it's not acceptable that you have noted correctly. Because when you see this, you'll understand why I'm saying so.
Market complex.
I don't know. I'm saying so for not for nothing.
Might have taken steps to for substitution. The substitution petition is perhaps not on record, my lord. So that may kindly be called for, my lord. Respondent number 3, my lord. Radha Bhushan.
Okay. Mr. G. Chaudhary, learned counsel for the appellant submits that respondent number 3 has expired and application for substitution has been filed. You got a copies? Copies not. Okay, Mr. A. Dekha, counsel for the respondent is present. Let a copy of the same be furnished to him beforehand. Next, the registry shall track and tag the said. So track and list the application for substitution. List after ensuing winter vacation.
Then might have kindly see office note dated 8/12/2023. Where the settlement officer was a party, respondent number 5, my lord.
Pardon me?
Respondent number 5 is a settlement officer, Guwahati Town Settlement Operation.
Yes.
Yes, but respondent number 5 has not been served, my lord. The reason behind these kind of these nomenclature is to be perhaps not kind of there, but then it appears in the plain like that. That is why we have made the party in this manner. So the learned governor would advocate maybe my lord directed to receive a copy, my lord, will supply a copy of the my lord entire material. to us.
You ask them, she will be able to tell you. For settlement officer, you can receive notice. Nomenclature is wrong, I think.
Nomenclature is wrong. At that time, it was perhaps there, but now it is not there.
Oh, okay. Next para. The learned counsel for the appellant further submits that in the plaint, the defendant number 5, the nomenclature of defendant number 5 is settlement officer, comma, Guwahati town settlement operation, comma, Guwahati 7. So he submits that perhaps the nomenclature is incorrect. Next para, be that as it may, as a settlement officer is the is a revenue official under the state, comma, Miss A. Fukan, learned K. Fukan, I'm sorry, learned government advocate shall accept notice on behalf of the respondent number 5. Full stop. On the next day, she shall the government advocate shall inform the court about the correct nomenclature of the respondent number 5. Full stop. Requisite extra copies of the memo appeal with enclosures be provided to the learned government advocate in respect of respondent number 5. Now this after vacation. Okay, the registry shall also reflect the name of G. Assam in the cause list for respondent numbers 4 and 5 while listing the matter next. (22)
Maybe
time being. There is no point in referring the matter to time being. Notice is not served, I think. Just go through it and address us.
on performer respondent has not been.
I don't know. I have not checked. After some time, you just tell us. We pass appropriate orders. No point adjourning matters for service report. 23.
This is completed. It respects upon the respondents.
Okay, you are appealing for all?
One,
two, three, four. Okay.
report has been called for, and that has already come. The hearing has been closed.
What about 5 and 6?
This is completed. Report has come.
Okay. Counsel for the appellant and respondent numbers 1 to 4 are present. Office note dated 19/12/2023 discloses that notice has been served on respondent numbers 5 and 6. Full stop. LCR has been received. Accordingly, release the matter for hearing in the month of February 2024.
Okay.
Yes, Mr. Mukit.
My lord, this matter was last listed on 22/5/2023, where the service report in respect of.
Yes, you have filed an affidavit.
Yes, I have filed an affidavit, and along with it, I have annexed the service report, which has been obtained through RTI in respect of these respondents.
Where is your affidavit?
At flag A. Flag. That will be page number 184 in serial.
One 84, yes.
So page 189 was my RTI application, my God.
Yes,
Where I had sought information regarding those notices which were dispatched through the through post, my lord. The names
Yes.
of the respondents are there. Saleha Begum, Samin Yasmin Ara Haq, Muhammad Ashraful Haq, and Afzal Salman Khurshid. There, your lordship, at page number 191 is the RTI reply, which has reference to my RTI application.
yes,
And point number B, it is written there, my lord. Certified copies of delivery slips are enclosed here.
okay,
So serially, those service reports are there, my lord.
okay,
193, my lord, at serial number 23, my lord. That Saleha Begum, she is, my lord, respondent number.
okay. Okay, then next,
And my lord, at page number 195, at serial number 11 is Samin Yasmin.
okay,
That is respondent number 4B. At serial number, at page 195, serial number 11, my the
okay,
bottom. It is received by her husband, Bulbul Hussain.
okay,
Then, my lord, at page number 197, 27, serial number, Abuzar Salman Khurshid,
okay,
respondent number 3B. So it is served, finally.
okay. This is advocate counsel for the petitioner. And Ms. R. Chaudhary, learned counsel for the respondent numbers. No, respondent number 1 are present. It's in the affidavit of service filed by the petitioner on 30/11/2023, and closing therewith the true copy of postal delivery record as certified by the postmaster, Mangalday Mangalday postmaster, received as per RTI reply, received as RTI reply, indicating that notice on respondent numbers 2, 3B, 4A, and 4B have been duly served. The service, the affidavit of service is accepted as due service of notice on the said respondents. None appears on call for the said respondents. Yes,
By an initial order which has been passed by your lordship, this matter, the proceeding of the title suit was stayed, and an issue was framed in this matter for decision by this honorable court. It was order dated 7/11/2022.
Lordship may fix a date for admission hearing, lordship, as
Yes.
okay.
Correct.
List after answering winter vacation in the admission column.
Interim order.
Okay, interim order passed earlier stands extended till the next date of listing. Make a mention if it is not listed.
Yes. 25 with 26.
Non-efficient call for the applicant. From office note dated 31/5/2023, it appears that notice is duly served on respondent numbers 1B to 1E. And service report on respondent number 1A is still awaited. So list the matter before the Lavazima Court for passing appropriate orders as regards service of notice on the said respondent. List the matter thereafter.
27.
In this case, survey is not complete for respondent number 1, 2. And earlier we had served the notices, but it is returned back. And now we come to know that respondent number 1, 2 has changed the address, your lordship, so we finally for service on the new address of lordship.
Which is their IA?
IA number 3534.
Okay. Mr.
J Das on behalf of SPO.
J. Das,
J Das.
learned counsel for the applicant, submits that from the returned steps, it came to the notice of the applicant that the opposite party number 1 within bracket 2 had changed her address, and therefore by this interlocutory application, the petitioner, sorry, the applicant seeks to serve notice on the changed address of the respondent number 1 within bracket 2, which is provided in the rear of the said application. Ms. S. Dasgupta and counsel for respondent number 1 and 1 2. 1. Okay, 1 and 1 3 is present. Next paragraph, considering the pair mate, comma, the same is allowed. Full stop, however, it would also be required to correct the postal address of the said respondent number 1 within bracket 2 in the connected revision. Full stop. This application stands allowed and allowed. This is 3534. Then in just in the connected revision as well as the connected IA Civil 2400 of 2022. Next para. This order in 2400 now. Mr. J. Das, counsel for the applicant, and Mrs. Das Gupta, counsel for opposite parties number 1 and 1 3. In view of order passed today in IA Civil 3534 of 2023, the registry shall make correction in the postal address of respondent numbers 1 with the respondent number 1 with bracket 2 in the cost title of the application. Next, the applicant shall take steps within 2 days for service of notice on the respondent number 1 within bracket Roman 2. 2 is Roman 2, huh? In the Roman 2 in the correct address of the said opposite party, which is notice is made returnable on 9/2/2024. The applicant is at counsel for the applicant is at liberty to collect the postal receipt number, submit postal track report, list on so and so.
Your lordship, there are like the 3 IA, your lordship, your condonation, abatement, and this one your substitution. So there are 2400, 2401, and 2402.
We will first issue notice. We are issued notice in the condonation application. Let that be decided. We'll issue a notice then.
Of like
no point multiplying steps.
Timing is ready for shooting.
Yes,
We have, service upon performer respondent number 3 and 4 is not possible.
3 and 4. Okay, Mr. C. Sharma and counsel for the applicant shall take first steps for service of notice on respondent number 3 and 4 by registered postal lady.
There is a, this note where it is said that it has been received by sister-in-law.
Pardon me?
It has been received, the notices on upon 3 and 4 has been received by, sister-in-law.
Received by,
Sister-in-law.
where is that? Right, why? Okay, you don't write that. You say that. uh, The as per the office note dated 21/1/2023. As per process service report, in respect of respondent numbers 3 and 4, comma, the sister-in-law of the respondent, said respondents have received the notice which is placed at flag Y of the part 2 file which is perused. Full stop. In view of the process service report, comma, notice on respondent number 3 and 4 is accepted to be duly served. Full stop. Accordingly, comma, there are only 4 respondents here. 5. State is already there. Full stop. Accordingly, case is taken as ready as civil service. Mr. B.K. Das, counsel for respondent number 1 and 2.
Yes. Well, 2 already expired, my lord, while the suit was pending, 2009. My lord, oh,
Okay, for number 1 is present and submits that the respondent number 2 has died during the pendency of the pension suit. Mr. T.R. Govil, and a government advocate, is present for respondent number 5. Oh, you're for 5. Okay. Your name? RB Goswami. Your standing counsel for respondent number 5 is present. Yes.
There is a delay of 633 days. That may be controlled.
633 days. What is the ground?
Ground is explained at paragraph 5, 6, and 7.
5, 6, and 7.
It is project due to some official delay, the official process, the delay has been caused.
What is the date of death? The respondent number 2.
The brother of the,
The respondent number 2 died.
yes.
one.
So if it is in the trial, they have died. Because now we are in revision.
Matlab, pro forma respondent number one, my lord. Mother, Nurun Nessa. She died 2009, my lord, during this.
Just a moment, I'm not being able to follow. Just a moment. Pro forma respondent number 2.
Pro forma respondent died 2020. And
Pro forma respondent number 2 is Jamaluddin. He died when? 2020.
And the title appeal was allowed, the judgment and decree, 22/5/2018.
Who is the appellant in this title appeal?
No. Plaintiff is the appellant in the title appeal, plaintiff suit was dismissed.
Plaintiff suit was dismissed. He is the appellant. Oh, okay. And the present revision is by?
ASTC.
By ASTC.
They have failed to place on record how delay, failed to explain the delay. This is the objection we have filed. And
But see, ASTC would not follow it up. What is the where is the plaint?
Saying that, annexure 117 of the CRP.
Page
Page number 17, Lordship.
17.
17. Lordship of the CRP.
17.
for recovery area in respect of land, my lord, not the building.
No, just a moment. But then you see, let me recapitulate what I have understood. The plaintiff is the respondent number 2 here. Plaintiff is
One, my lord.
Kamaluddin Ahmed. So who has died? Jamaluddin Ahmed. Okay, similar name. Okay. And there's no relief claimed against him. Correct. So why you are contesting this substitution application? He is nobody, not affected. It doesn't affect the merit of the appeal.
He has not filed substitution.
So,
Condemnation of delay.
condemnation delay in what?
Filing this CRP.
This CRP is under which provision?
And that is the one that we have taken the ground, my lord. Hello, since
Just a moment. Provision under 115. How revision under 115 would be maintainable? The suit is for recovery of rent. For recovery of rent,
rent in respect of land, my lord.
No, whatever way, I'm not bothered with that. It's recovery of money. Recovery of money, there is a first appeal. After that, how can a revision be entertained?
Should be second. That is the ground we have taken.
We just add there this. On the perusal of the unnumbered revision application, it appears that the original suit was filed by respondent number 1 claiming area rent. Full stop. Therefore, it appears that it is only a money source simply cited by the plaintiff for recovery of rent. So therefore, as per the procedure prescribed, against a decree passed in a money suit, there will be a first appeal under section 96 CPC, and thereafter it appears to the court that if somebody is aggrieved with the first appellate judgment, it will only be a second appeal where the appellate decree can be assailed. First of the connected revision being one and filed under section 115 CPC read with article 227 of the Constitution of India, the learned counsel for both sides had addressed the court on the next date on the maintainability of the said division, which is still unnumbered, as it first off, it appears to the court that if the issue maintainability is taken up, it would not prejudice the parties, because the court is also required to consider the prayer made in this interlocutory application, which relates to condonation of delay in filing of the said revision. Next para. List after answering winter vacation.
8 PM fix.
I am not fixing right now.
Application has been started.
Cannot be.
You make a prayer after vacation, because I am not fixing a date. I'll not be able to manage the board. You see, we have 4 vacations. Just what you call, when January comes, first prayer would be list after due vacation. We just tide over that vacation. Then prayer is that is list after summer vacation. After summer vacation, when matters are listed, prayer is that list after what you call puja vacation. Immediately after puja vacation, you don't allow us to do anything. List after winter vacation. So just tell us in these days, with 210 working days, how will I manage my board? If you have an answer, we'll be very grateful. Correct? We'll be very, very grateful.
Give us a copy of the CRP. Yes. Our names.
Okay, the name of, no, he will be appearing as ASTC. This GA is not there. Assam is not there. ASTC is there. Give a copy.
Obliged.
Right. $28.
I have to take steps on respondent number 6, B, D, and E.
It is your lordship. Here also, your lordship, same thing, lordship, execution court order 115, so condonation is there. 115 is not maintainable, lordship. 2001 RSA, lordship, my execution is pending.
Okay.
Another case, IA civil number 67 of 2023 in RSA 89 of 2001. That was listed yesterday, lordship. So that may kindly be connected with this case, lordship.
Just a moment. First thing first. Mr. Shi Sharma, then counsel for the petitioner. Was referred to the office note dated 7/12/2023 and placed for some time to take fresh steps for service of notice on respondent numbers 4B, C, D, and 4B, C, 4D, 4E, 4G, and 4H. Oh, acha, no. Okay, 4B to 4E. Huh? আগতো কাটি দিবি।
For them, I am appearing.
Lordship, six,
You are appearing for them.
6B.
42.45, 47, 48, Lordship, I am appearing.
Ah, yes, that is on record. No, no, I'm just first taking orders of the steps. Just on. The learned counsel for the applicant shall take first steps for service of notice on the said respondents within 2 days. Notice is made returnable on so and so, list accordingly. Just before that, list accordingly, just strike it out. Mr. A.C. Sharma, then it's senior counsel, assisted by Mr. N. Brahma, counsel for respondent number 1 and 2, as well as Ms. R. Chaudhary, Mrs. R. Chaudhary, then counsel for respondent numbers 4B, C, D, E, G, and H is present. And it is submitted that the what is the suit about?
Lordship, it's our copy, Lordship, I have requested.
No, you are asserting the revision.
Lordship,
You are saying revision is not
I have
maintainable.
gone through the file.
No, you say this is a revision, is not maintainable. Why?
Execution is pending and Lordship, executing court passed some order, Lordship, against that 115, Lordship. I have.
Oh, acha. Okay. So it is submitted by the learned counsel, who has submitted that this, by this, by the connected revision application, which is filed under section 115 CPC, interlocutory orders passed in execution proceedings of title execution case number 4 of 2016 has been assailed. And accordingly, she has questioned the maintainability of this, of the connected unnumbered revision. First on the next date of listing, the learned counsel for the appearing parties shall address the court on maintainability of the connected revision application. Next para, the adjudication of the maintainability of the said revision, unnumbered revision, shall not prejudice the parties, as this is an application. The present application is filed under section 5 of the Limitation Act for condonation of delay in filing the revision application, whose maintainability itself is a question of challenge.
It's required to serve notice in condonation, Lordship has already.
No, you see that has to go on, because otherwise, if we supposing we decide this, then there is no service, we can't do anything. Let the steps be taken. Correct, but maintenance we will decide. Otherwise, service is incomplete. If we have to pass any adverse orders against them, we can't do it.
Then Lordship may kindly fix IAS.
No, they will give a date. Date I am not fixing. I am depending on my court master.
Kindly tag IAS civil number 67 of 2020.
How it is connected?
Lordship, that is RSA is pending since 2001, Lordship.
No, RSA and CRP, please don't tag together. It will be difficult. I am hearing this on the maintainability.
Same.
But you see, we are deciding on the maintainability here. So why is RSA should be tagged and then cases be stalled? RSA, let it go its own course.
Says also, Lordship, that
On the next date, you make a.
IA is pending, Lordship.
No. You see, it may be between the same parties, but the leases are different. You are now questioning the maintainability. Why should you tag the RSA and keep it here? Correct. Make a mention when you when
Be
this.
directed to serve as copy, Lordship. My senior
Yes,
friend
yes.
is also.
Okay, give her a copy. Correct, because I am questioning the maintainability. 29.
Find this miscase, only one correct.
Oh, button up your coat. Open coat, I don't dislike. Yes.
This miscase, Your Lordship, just a small correction. In the judgment, your lordship find, paragraph, 21.
21.
21, your lordship. Page 18, your lordship.
Page 18.
Respondent number 234, yes, children of the disease was mentioned, my lord. Just
Which paragraph?
Lordship, 21 paragraph.
21, yes.
Here is respondent number 234, yes, children of the disease was mentioned, lordship. There, respondent number 4 is the, sir, your lordship, father of the disease. It should be the father of the disease.
Oh,
For that
acha.
reason, registry held up, withheld
Okay,
the
okay.
payment. And then,
Mr. N. Devnath, Learned Counsel for the applicants. And Mr. R.K. Bhatra and counsel for opposite party number 1 are present. Next, the learned counsel for the applicant has submitted that a typographical error has crept in paragraph 21 of the judgment and order dated 15/5/2019, passed in 15/5, I said 15/5/2019 in MSc appeal number 156 of 2014. It is submitted that the respondent number 4 is the father of the deceased, however, in the said order, it has been mentioned that the respondent numbers 2, 3, and 4 are children of the deceased. So it is submitted that due to said typographical error, the payment required to be released to the claimants, applicants, has been held up. Next para. The learned counsel for the opposite party number 1 has no objection to the prayer. Next para. On considering that in the claim petition, it is projected that the respondent number 4 in MSc appeal number 156 of 2014 is the father of the deceased, the court is inclined to incorporate correction of the description of the parties as appearing in paragraph 21 of the said judgment and order dated 15/5/2019 in MSc appeal number so and so. The words inverted commas and number 4, numerical 4, appearing in line 7 of paragraph 21 shall stand deleted. And 4, appearing just before the number, just before numerical, just before number inverted commas 3 shall stand deleted. And but then the father would not be entitled to claim.
there is no mention, that father will get, some award.
No, because it will not. There are judgments of various courts, including this court. The father is not be entitled to. So this equal share of 40% will go to the children, and mother will get it. So this is also incorrect. It should not be 15. It should be equal share would be how much?
Respondent number 1 will get 35% and 40%.
No, just by 35,
40.
40 to the children.
15 will be
To the mother.
mother. Remaining
okay.
8%, that was we also mentioned, equally divided in the between the claimant. Later on, your lordship find 9 number line. 10% also given, equally divided to the claimants.
So as it would, full stop, having done so, it is observed that the deletion of the name of respondent of 4 would require a recalculation of the distribution of compensation.
As per Rajapriya, as per the decision of Rajapriya.
So this 10% has come, we can add it to this and undo everything. Correct. Now, how much it will become if 10 is apportioned? 35 will become 40.
35 will become.
Mother and children will have equal share.
Yes.
Correct. So this 35, respondent number 1, respondent number 1 is who?
Wife
Wife
of
of the deceased.
wife of the-
Wife. So she gets just do the calculation.
What I submitted. This distribution was done considering the decision of the Rajapriya, that the apex code has laid down. That the wife will get 35%,
Okay,
children will get 40%,
40%.
and the mother will get 15%. The rest 10% which remains will be equally shared by the respondent wife and the mother. So if your lordship feels that the share should also go to the children, then my lord, it can be equally.
No, then we'll make it, if this becomes 40, the mother will get 20 then,
Yes, your
end of the matter,
Yes.
recalculation.
Wife of the deceased will get 40.
As the 10% remaining share would be equally, will become equally divided between the wife of the deceased and the mother of the deceased. So accordingly, the restructured sharing would now be read, would now become, would now entitle the respondent number 1 in the said appeal to get 40% of the compensation, comma, the respondent numbers 2 and 3 would become entitled to equal share of 40% of compensation, and the and respondent number 5, being the mother of the deceased, would become entitled to 20% of the compensation. So this dispenses with sharing of for recalculating the remaining 10% share of compensation. So accordingly, the corrected paragraph 21 shall now be read as follows. Paragraph 21, page 18. This part will be altered according to this. Next paragraph, this order shall be read together with order the judgment and order dated 15/5/2019, passed in MSC appeal number 156 of 2014.
If I'm not wrong, same correction will also be required in paragraph 52.
In page
Paragraph 20, same page.
22.
Yes. Here also insofar as.
Okay, full stop. For the demand. So the para number 22 is also required to be suitably corrected, and therefore the words and figures appearing after numerical within the inverted comma 3 being inverted commas and 4 inverted comma closed shall stand deleted. Resultantly, paragraph 22 shall of the said order shall now be read as follows. and 4 কাটা যাবে। Okay, correct. We'll reassemble at 2. Mr. Mahato, please come inside. I have to say something to you. Come in the chambers. I'll have to say something.
My lord. And
You know
as per the
something?
plan,
I'll tell you something.
My order 26 rule 9.
No, there's something else I'm trying to show you. Just a moment. Yes. Yes.
License.
Now, what happens is that it is just like a ROW, right of way. Once that is given, the normal suit, I don't know whether that can cover this position or not, because now you understand. Once the mining lease, then deputy commissioner, then all these people they're coming in. So it's not only the question in this suit,
Exit.
but those issues will arise. Can I take it tomorrow?
Not tomorrow, after the- I'll go through it tomorrow. I have.
Tomorrow you have some
Yes.
problems.
So that is my lord. If that is so, then my security woman.
No, I don't, that's why I'm just pointing, I'm not saying anything, I'm just pointing it out.
I understand.
I'm just pointing it out.
Then otherwise I came before this, I will put only on the count of my lord, my order 26 rule 10 and 9 petition has been dismissed. That's why I'm before you.
I understand that.
But yes, that the root of the case. The lordship goes by that without license. That all after this.
Okay, you are difficulty tomorrow.
I'm grateful to your lordship, yes, this is my,
No, no,
because
it's okay.
I have not, my lord, gone to that regarding that.
No, here,
Very
that old experience comes.
My pleasure.
Uh, choose a date. There's a calendar in front of you.
My lord.
It's a motion matter. You just choose a date.
Yes, yes. On fourth, my lord.
Oh, okay. On the prayer made by Mr. T.J. Mahanta, counsel for the senior counsel, assisted by Mr. P.P. Datta, counsel for the petitioner, list on 4/4/2024.
My dear,
4, sorry,
I
4/1/2020.
have not gone to that.
No, no, you see, it's nothing, just it struck me and therefore I'm just.
I'm being item 9.
Just note that provision.
So Dipankar Nath was there some time ago, but yes.
He was here, he was just here. After some time, he was here, I just saw him. After some time, yes, no, don't worry. Item 30. Oh, that matter, 9. Okay, 9.
So it's a regular first appeal against the judgment and decree passed in Manipur 135 of 2017. It was passed on 2nd of March.
Oh, I did not see it. I may not like to take this up. Not before this bench. We'll listen tomorrow.
Lordship, after that is.
This is the first appeal.
Otherwise
It
there
will
is
go in
no-
execution. Let it go tomorrow. Before the
There is no
bench.
application for stay loss.
It's not there. No, it is here. Oh, it's a caveat. Okay. Okay, this is matter before any other bench without me. Listing the motion column before the appropriate court on before the bench on 3rd January. Okay. I had not seen the name. Mr. Nath. I had not seen the name. Only after I opened up, see the names and that. Okay. Yes, item 30.
Please, Your Lord.
Yes.
My lord, service has been completed and the respondent has appeared these items. And my lord, LGR was called for, it has been received by the section, however, it is just.
Just a moment.
Also, I'm appearing on behalf of respondent.
Just a moment. This appeals under against order of remand. Okay. Yes,
Lordship, in this case, respondent number 1 has already been died.
respondent one has died.
Yes, Lordship. On
When? 7/5/23. Which respondent?
Navakanto Goswami, respondent number 1.
Okay. Mr.
S. Rava.
S. Rabha, counsel for the appellant. Mr.
M. Boro.
M. Boro, counsel appearing for respondent numbers 2 and 3. Upon instructions has submitted that the respondent number 1, namely Nabakanta Goswami, has expired on
7/5/23.
7/5/2023. Full stop. The learned counsel for the petition, for the appellant shall take note of the submissions and take appropriate steps. List after ensuing. Just say, it also appears that the LCR is received. Full stop. List after ensuing interrogation, by which time the applicant shall, the appellant shall do the needful.
31.
Under the state of the respondent number 1 could not be served in spite of the additional force necessary.
Just a moment. Just a moment.
As well as the.
Just a moment. All these pages are gearing up. They're getting damaged. So what is to be done, Mr. Sharma?
Take steps by testing. Because we send the notices to the address given to the plaintiff. That was not charged. But the respondent number 1 is that place. So we will be allowed to take step by testing.
By the C, okay. You also take by registered post so that you collect the postal receipt number and give us postal track report, correct? Mr. A.C. Sharma, Senior Counsel, assisted by Mr. M. Rabha, then Counsel, submits, has referred to the office note dated 13/12/2023 and submits that the applicant may be permitted to take steps by Dusty mode. Who's from Mr. SS S. Hazarika, Counsel for Respondent number 2 is present. Next part, the prayer of the learned senior counsel for the appellant is allowed. Next part, the appellant shall take steps within 2 days for service of notice on the respondent number 1 by registered post with AD as well as by Dusty mode by routing the process through the registry of the court, and upon service an affidavit of service shall be filed prior to the next date of listing. The instructing counsel for the appellant is permitted to collect the postal receipt number and submit postal track report prior to the next date of listing. Next part, the notice is made returnable on so and so, list accordingly on said date. Okay. 92. (32)
That is allowed. Well, this whole important has already appeared here. The LCR was all for that. That is also.
Just a moment.
I have appeared long back and Lordship, I have some urgency because the order of maintenance is under stay, Lordship. So my humble submission is just the simple issue, Lordship. It is already covered by decision of Honorable Supreme Court in Rajneesh versus Neha that if there is full
Oh,
decision.
without facts, why jump to Supreme Court unless I understand the fact? Let him submit. He is the petitioner.
That your lordship, the board has filed a petition under section 24 of Hindu Marriage Act. That petition was allowed, your lordship. Giving 15,000 maintenance pendant light in favor of the respondent, your lordship. But the fact
Yes.
is that the petitioner.
What is the order under challenge? Show me the order first. Where is the impugned order? Which page?
Yes, 20.
Page 20? Yes.
This is the order, your lordship.
Yes.
Yes, 28. But the fact is that, your lordship, the petitioner was not given any opportunity to contest this case, your lordship. But in page 28, your lordship, it is reflected in the order. I find, second para, your lordship. I find that the respondent has not participated in this case in spite of receiving a copy of this application. But in fact, your lordship, if the lordship will go by the order passed by this court, then no such order your lordship will find it serving copy to the petitioner, your lordship. And the petitioner has already paid maintenance, your lordship, as per order passed by the honorable court.
Yeah, just a moment. But then you come to page 23.
Yes.
Now, whose signature is that received copy? If somebody has received a copy, then you'll have to ask the court to lodge an FIR, have that investigated, have this person arrested.
I don't know, your lordship.
But this somebody has received it is not on a challenge.
But in fact, your lordship, no copy has been served to us.
You see, in a matrimonial suit, third party will not come and receive your copy.
The petitioner came to learn about passing this.
You see, all these have very serious consequences. I'll tell you why. There's a order, a judicial order of this court authored by this bench, where I have ordered that the registry shall not accept the filing unless it contains the same signature of the advocate who is there in the Wakalatnama. You see, exactly similar thing happened. Somebody files short signature and then denies that this was not my signature. So if that be so in the entire jurisdiction of this court, I have to pass an order that no application at all will be entertained without the advocate on record accepting any filing. So it won't permit you to send your junior lawyer whose name is not there in the Wakalatnama to do anything. And signature must match, just like a bank.
My humble submission is that, Lordship.
Just complete, let him complete. You are wanting to catch a train at 3 o'clock
I'm sorry.
or a city bus? Because in Calcutta or Bombay, if you miss a 2:41 bus, perhaps the next bus will come after half an hour. So people in Calcutta and Bombay, I know that they go by time. They miss a train, local train, they can't get a train after half an hour. Correct. If you want to catch a bus, you catch it. We'll take it up after some time. If you are here, please be patient. Correct. Sit down.
Sorry, Your Lordship, that petitioner, he got the information only in the month of November.
No, that's okay. But you see, who has received it? We'll have to make an inquiry then. If somebody has received and you are not questioning it, the inquiry ends here. We just say that the receipt itself is not under question. In this family court proceedings, is CBC applicable? In Family Courts Act, what does it say? Is CBC applicable? Family Courts Act. Family Courts Act. Actually, red color or red color. It will be. Yes. Now you see this, that is why I was referring to section 10 of the Family Courts Act. Refer to this, refers to application of CPC in the procedures before the family courts. Oh, this was not a family court. It was a civil suit divorce. So CPC applies. So if something goes ex parte, you have a right to approach the same court under Order 9. If it is an ex parte, then 227 would not apply.
But in the order, Your Lordship, it has written, I find that the respondent has not participated in the suit in spite of receiving.
It's okay. This can be, you see, I'm just asking you the procedure. If the procedure prescribes for an alternative remedy which you have, why would the court exercise jurisdiction under 227? And you see, when in 227, I will have a narrower look than in an appeal or an application for setting aside, because I would, just why I'm showing you at page, at this page, it is that somebody has received it. So your plea it has not been it has not been served, or you did not participate, will only lead to a conclusion that you did not participate of your own will once you receive the copy. That is one part. So there will be no jurisdictional error.
But in the order, Your Lordship, it has been reflected that after receiving the copy, the petitioner.
You see, that's why we are showing it to you, that copy somebody has received. And that is not under challenge, that this is not the signature of the, yeah. You see, because you see, when I passed that order, asking all of the lawyers to countersign all the pages, there was a resentment in the bar. At that point of time, now people have forgotten, they are now accustomed to write, because if a paper book is filed of 200 pages, you have to make the same signature. So it was causing problem at the members of the bar, and therefore there was a huge objection against the order which I had passed. And that was same thing is here. Somebody receives it in a court proceedings. A third party will not come and then take away by signing it. So either you are advocate or the party would have received it and they give a short signature. So today I prohibit that in the entire four, this law will operate in entire 4 states. So therefore, a chamber junior who's not a counsel holding the brief will say that under the civil court rules and orders, they will be prohibited from handling the file. These are issues which I have to address. And these issues will lead to large resentment in the lawyers. So you'll have to do something and challenge that signature. Because there is not challenge that you'll have to do it. And then secondly, if you want to approach the appropriate forum, same court under order 9, you are permitted to do so.
It is, this order was passed on 25 to 2023, 2022. And the question of limitation will arise here, Lordship, because.
No, we can, you see, you see this application was filed.
That liberty, your Lordship.
No, I'll tell you, you see this, I can only pass orders which is within my capacity. Legal capacity. You see, this application was filed on 16/2/2023. This present application. So I can only extend what you call grant you benefit of section 14 only from 16/2/2023.
Because the petitioner, he came to learn only
No,
in
no.
the month of November.
No, not that. Please try to understand what I'm saying. My jurisdiction to make the order, make the application condonable would only be from, commence from 16/2/2023 till say 15-20 days time I allow you to file an application. I can only say that the limitation would not run on that for that period. I can't condone any other application because I am not dealing with section 5 application. I have my limitations. Correct. So when was this order passed?
Order was passed on 22/5.
25/22. So you see, from 1 year I can't condone that delay. That is a
2020.
that is something which I can't condone. That you'll have to make your own explanation. Because we are not dealing with a condonation application. You have to show me a way that the court has power to condone the delay which is prior to the filing. That perhaps we will not have. Because section 14 say that litigating in a wrong court. It will only operate from that period only. I can't. So this will be a wrong court because if you
Order itself reflected that the petitioner participated.
no, you see, I'm only thinking aloud. I'm not forming an opinion. I'm telling you the concept, the various laws which would be applicable. 227. We have told you what is the limitations. We have told you order 9 has certain implications. We have said under 14 the condonable period available to the court would only be from applicable when the matter is before this court, assuming that this court is a wrong forum. But the power to condone from the impugn order till the date of filing, that is not perhaps available with us.
Your Lordship, if your Lordship will take up this matter after vacation, your Lordship, so that I can.
Okay, yes, what do you have to say?
My humble submission is that this is a factual issue, whether copy was received or not. And the first court is Lordship the trial court. So they could have very well approached, as your Lordship rightly pointed out, under.
No, that we won't say. What he can do, it is for him to decide. I'm not for him, I'm not giving him any, I'm not giving him counseling. I'm prohibited to advise someone.
Yes, my also submission is that Lordship, they have alternative remedy without exhausting that. They
No,
can
let him take a decision. You see, when a lawyer asks for a time to take a call on the legal provision, I'm not preempting them.
My difficulty is that Lordship, the order is under stay since 22 February. And this is the lady.
Your Lordship,
And a
in the
child
meantime,
is
he has been paying your Lordship.
Just a moment.
she is a lady and she has a child to maintain who is reading in class 7 now. And order is under stay since February, since 22 to 2023. So therefore, there is no urgency on their part. And
Okay.
so I have urgency, Lordship. Order is under stay, the order for maintenance, grant of maintenance.
How much is the maintenance granted?
15,000 was granted, but that is under stay.
Earlier, your lordship, 10,000 is there.
No, 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 no.
Order
10,000.
25.
So for how many months you are yet to pay from 22 till now?
That is because arrear was there, so it was made 10,000.
No, it's okay.
Initially, your lordship in 25 proceeding, your 125 proceeding, your lordship 7,500.
500.
But some area there was and accordingly 10,000. 10,000 and for this 15,000. The lordship kindly see the page 23. your
So,
lordship, case
no,
in-
just tell me what is the, from which date you have stopped paying?
From the date of passing interim order. your lordship.
From the date of passing of interim order. The interim order was passed on 22 to 2023. So you deposit 1 lakh rupees on the next date. You're fixing it on January 5th. By that time, you deposit 1 lakh rupees.
Lordship, in page 22, your lordship kindly see, this is the pay slip, your lordship. Kindly see there.
Page
The gross, page 22, your lordship.
22.
The gross pay of the
Yes,
petitioner,
just let me find out 22. Just a moment. Yes.
this is the pay slip, your lordship.
Hmm.
Gross salary of the petitioner is 54,888.
Correct.
And after deducting all liabilities, the petitioner receiving 13,333 rupees. your lordship. And
What is this attachment at 25,000 rupees? What is that?
attachment means-
Area.
Attachment means 15,000 for this and 10,000 for the earlier proceeding. your lordship. In the-
10,000 for?
For earlier, your lordship, in 125 proceeding, materials has been granted, your lordship, 7,500.
No, for 10th, you see, no court will attach 25,000 for a payment under 125 for rupees 7,500. Out of question.
No, no. The order was like this, deduction was made from the salary, your lordship. Maintenance amount has been deducted from the salary of the petitioner. What I got instruction from my client, your lordship.
No, no, this 25,000 must arise out of some judicial order.
Yes,
So what is that order? You see, for 7,000 rupees or 10,000 rupees, no court will attach 25,000 from salary.
what I have been instructed my.
No, no,
client,
those,
your
those things won't go. Because the fact is, you see,
15,000 from this case,
no, no, you see, can I speak something in a lighter tone? I can, you permit me. You see, search your mobile for a very interesting news. You search the richest beggar in India. Search it out, search it, you will find it. There's a beggar who was caught by the IT income tax trying to buy a flat of 30 crore in Bombay. You look at his annual income and he's a street beggar. He stays on the road and begs. His income out of begging led him to purchase a flat of 30 crore which flagged the income tax authorities and his premises was raided. Search it, you will find it.
yes, some Bharat Zen like this, your lordship.
But you'll get it. In your free time, do it. He's the richest beggar in the country. He has got 18,000 beggars under him. He operates in several countries, including India. And he's only a beggar. Street beggar. He stays on the street. Correct. So therefore, when it comes to this, what do you call these unusual things, I read that when I have free time. This is the only thing I do. So the question is, you see, your capacity of earning is, let us say your salary is 58,000. Now you create liabilities and then say that my take home income is only 200 rupees. And therefore from 200 I will have to survive and I will have to give my wife, estranged wife, what do you call, maintenance of, say 50%. So she goes home with only 50 rupees in today's world. Is it acceptable? So if you are enjoying a stay for 1 year, we'll ask you to pay 1 lakh rupees.
Regarding that part, your lordship, I am saying.
You can't do it. Otherwise, we'll hear it. We'll,
He is sitting right now, your lordship.
no, no. Therefore, you see, we have heard. We have given you options. So I decide the matter today, just now. Why should I linger?
10,000, your lordship, he is receiving right now, your lordship. He has an old desert mother, your lordship.
No, no. You see, these things, you see, in this court, I always give that statement. Perhaps I am repeating it for the 100th time today. You see, a few days back, I was ill. I went to a doctor. They checked me up and told me, sir, you don't have a heart. That heart was missing. So that compassion along with the heart has gone away. The question is that I have a matter to decide. I will decide it. If I have to hang a person, I won't bother for a moment that I am hanging a person. I am ordering, giving a sentence to hang a man to death. It would not bother me. If somebody doesn't have income and I am ordered to pay a compensation to the wife for maintenance, it would not bother me.
But I am only the quantum what you have given, your lordship. I am submitting from the pay slip, your lordship. At present, your lordship, he has.
But if you don't pay and then you see you can't enjoy a stay, you'll have to say something if you are adjourning the matter. If you are adjourning the matter, you'll have to give some money to your wife. We can't permit her to follow the footsteps of that gentleman who is
I am only before your lordship.
who is a beggar.
Regarding the quantum, your lordship, what you were given, that quantum is not sustainable. Because of this person, your lordship has already been paying your lordship 10,000 too high. And again 15,000, then altogether 25,000, it is not possible for him.
We'll take it up at 4:30. Can you tell us the what you call the arrear dues which you are to pay from 125 proceedings and arrear which has accumulated in this account? Can you do the arithmetic and tell us? At 4:30. Wait. Because the idea is very simple that you'll have to give something to the wife if you are paying for an adjournment in a maintenance matter.
As I have been instructed, your lordship, earlier there was some.
I don't know, just give me the arithmetic. I understand arithmetic better.
Paying 10,000. Actually, 7,500 there was.
No, whatever be. You see, if you write it down, I'll understand it better.
May I submit just one thing?
No, at 4:30. We are fixing it at 4:30. 34.
My lord, I am for the opposite party. I people fight.
Yes.
Some, my lord, mistake is there in the order, last order, 4/12/23. Because my lord, I appear for opposite party, not as applicant. My lord. You RFA, my lord, in fact, my lord, file earlier, she was already compromised, my lord, and closed. Thereafter, my lord, 1 lakh rupees there remaining with my lord for applicant Rana Padgiri. My lord, I submitted letter again.
Oh, acha, acha. Okay, okay.
I have no objection.
Okay. Who will be withdrawing this money?
The Rana Padgiri, applicant of 555.
Rana Padgiri. Okay, okay. None appears on call for the 34. For the opposite party. Next para. This matter has been listed at the on the basis of a letter dated 23/5/2023 submitted before the registry of this court by the respondent Full stop. By the said letter, it has been brought to the notice of the court that in terms of directions contained in order dated 29/11/2019 in RFA 128 of 2019, the respondent had deposited a sum of rupees 1 lakh before the registry of the court by check number 221984 dated 27/2/2020 drawn on UBI, Dispur branch in favor of the Registrar General of this court. Full stop. Next para. In course of the proceedings of RFA 128, of 2019, the appellants had filed an application, a interlocutory application to permit them from withdrawing the said RFA 128 of 2019 in view of compromise public settlement of the matter outside the court. Accordingly, this court by an order dated 10/3/2023 allowed the prayer for withdrawal, and this interlocutory application together with RFA 128 of 2019 was closed. Next para. From the note of the registry and from the submissions made by Mr. S. Chauhan, London Council for the applicants.
I thought 333 Mela, I am opposite party, I am not applicant.
No, this IA is
I filed by my lord this.
Srikanta Lalung.
Yes,
Srikanta Lalung is the appellant.
I am Srikant Lalung, my lord, but for release of amount, people.
Don't tell that. Please understand the order which I am passing. For the applicants, it appears that the sum of rupees 1 lakh, which was deposited by the respondent, is still lying with the registry of the court, despite allowing the connected appeal to be withdrawn. Therefore, next para, therefore, in view of the prayer made before the registry of the court by the opposite, by the respondent, the court is inclined to allow the registry of this court to permit withdrawal of the deposited amount of rupees 1 lakh back to the respondent, namely Rana Padgiri. So rupees 1 lakh deposited with Rana Padgiri. Full stop. Next para. The respondent shall provide his bank particulars to the registry so as to enable them to make online transfer of the electronic transfer of the funds now for sum of rupees 1 lakh to the respondent. Stop. Next para. This as the connected appeal as well as this interlocutory application has already been permitted to be withdrawn, the records may now be consigned to these files may be consigned to records. Okay. Advaita, it is also noted that the LCR is still lying with the records. Full stop. Let those LCR be returned back.
To the respondent, we can run a party.
Don't worry, we take responsibility of our orders. 35.
Service on response number 7 is, let's say, unserved notice, not yet received. But
Unserved notice on so-and-so is not yet arrived.
the owner of the vehicle and some quantum. It's already here.
Huh?
The payment said is a 20 days.
It's only quantum.
Number 7.
Okay. Upon instructions, Mr. R. Goswami, learned counsel for the applicant, submits that notice on respond number 7 has not been returned back. So it is submitted that in the connected appeal, the applicant has only challenged the quantum of compensation for which the owner of the vehicle, i.e. respondent number 7, may not be a necessary party. And accordingly, he prays for striking out the name of respondent number 7. So prayer is allowed. The name of respondent number 7, who is the owner of the vehicle, stands struck off. Full stop. How many days delay? You are opposing it? You are opposing? You are opposing this prayer? Okay. This is an application under Section 5 of the Limitation Act, read with proviso, second proviso, right? Delay is second proviso. Second proviso to Section 173 of the Motor Vehicles Act for condoning the delay of 61 days beyond the period of limitation in filing the connected appeal. Mr. H.I. Chaudhary, learned counsel for the respondent numbers 1 to 6. 1 to 6 has opposed the prayer. However, considering the explanation tendered by the applicants that that some time was consumed in obtaining certified copy from the dealing advocate and from taking decision to file an appeal, the delay of the delay in filing of the had occurred. Next, the explanation tender is found acceptable, and therefore the delay in filing the connected appeal stands. Delay of 61 days beyond the period of limitation in filing this, the connected appeal is condoned. This interlocutory application stands allowed. Next, the registry shall now register the connected appeal and list the same in the admission column. Next, while listing the connected appeal, the registry shall reflect the name of the learned counsel who have entered appearance for the respondent numbers 1 to 6 and respondent number 8 in the cause list while listing the matter next. Yes. What is the error?
But your lordship. It is to grant to page 10, my lord. So, my lord, citizen, when this interim
Page
bail
18.
petition, who were granted interim bail, my lord.
Page
Page 10 onward.
10. Yes. What is the error?
Who was granted, well, I am coming, who was granted interim bail.
Yes.
Thereafter, my lord, when the case finally disposed of by order dated 38/2022,
Where is that?
that is at page 13, my lord.
13. Yes.
So here your lordship, last paragraph, your lordship granted me the interim bail. So my lord, my humble submission before your
No,
lordship.
just show me. Please identify that place, otherwise I will not be able to find out.
Para 13, my lord. So
Para-
page 13,
Page 13.
last para, my lord.
Okay, this is an error.
Under
Okay.
such circumstances, the court
Interim.
is of
Okay.
consider of it.
Okay.
So my lord, interim period bail. that
Correct.
interim is to be there.
Correct.
It should be period.
Correct. Heard Mr. M. A. Sheikh, counsel for the applicant. APP is, no one is there. APP was here. What was his name? KK Das. sir. Mr. KK Das, learned APP for the state. Next para. This interlocutory application has been filed for correction of the typographical error which has crept in the order dated 38/2022 passed by this court in AB 2028 of 2022. Next para, it has been pointed out, as pointed out, it is seen that by the said order dated 38/2022, this court had granted bail to the respondent numbers to the petitioners,
To the petitioners.
to the petitioners. However, in para 5 of the said order, a typographical error has crept in and the inverted comma pre-arrest bail has been prefixed with the word inverted commas interim at in 3 places. Full stop. Next, accordingly, it is provided that the reference to interim inverted comma interim pre-arrest bail as appearing in the order dated 38/2022 passed in AB 2028 of 2022 shall now be read as interim inverted commas pre-arrest bail, and the word interim would stand deleted. First off, this order shall be read together with order dated 38/2022 passed in AB 2028 of 2022. Page 13 में correction. Okay.
38.
You can take this method after completion. There is delay of 5,000 and odd days in filing the petition.
5,000.
So I take instruction.
Okay.
For delaying filing subsidy.
Okay. Both sides are duly represented. Due to positive time matter could not be taken up today. List on after vacation.
After petition.
Now I need for 1 month
To negotiate. Negotiate or communicate.
only career type for a conversation.
No, that's why I'm asking you. I could understand, but still, I can't.
Because
No, I cannot shed out my habit. List after answering, but list on 22/1/2024. Okay. 39. 39. Yes.
In terms of order dated 11/20. Our paper publication is done.
You filed your affidavit?
No, Lordship.
Okay. On the prayer made by Miss as Dev, counsel for the Dev DEV, counsel for the applicant. Matter stands adjourned so as to enable her to file an affidavit to bring on record the relevant newspaper. First, paper publication of notice, list after ensuing winter vacation. 40. Just a moment. Yes. Compromise matters, compromise. Okay. Heard Mr. J. Teka, counsel for the applicant, as well as Mr. B.C. Talukdar, learned counsel appearing for the opposite parties. Next para. By this joint application filed by both the parties under by the applicant as well as the respondent numbers 1 to 5 under order 23 rule 3 CPC, it is submitted by both sides that the matter has been compromised outside the court, and it is prayed that the compromise decree be drawn up in accordance with the said agreement between the parties.
The agreement may be a part of the argument.
I will do it. The said agreement is at annexure A.
It's 70. Extend
From page 17 to
29.
24. 25 is something else. Was it 25? Okay, 25. 25. The compromise agreement together with without acknowledgement of receipt of demand draft. Next, annexure A and B of this application from pages 17 to 25. Stop. Next paragraph. As the learned counsel for both sides have accepted that the compromise was made by both the parties in their own free will and without any coercion, this application stands allowed. By permitting compromise agreement with the parties to be made a part of record. Now in appeal you write RFA. Next para. In view of the order passed today in IS Civil 3128 of 2023, this appeal stands dismissed on decreed on compromise. The compromise agreement is annexed as annexure A to IS Civil 3128 of 2023, and the acknowledgement of receipt of demand draft is annexed as annexure B to the said interlocutory application. Both the memorandum of understanding as well as the acknowledgement of receipt of demand draft be made a part of the decree to be drawn up on compromise. marking the said MOU with letter X. Letter is LATTR, letter, inverted comma, X, and letter, inverted commas, Y. First, let a formal decree be drawn up accordingly. Appeal stands disposed of on compromise.
Forty-one. If you look at the substitute reading, case 4 million, the respondent of 4 million expired. 4 million, I have only 6 all of the parties
Died when?
died in time.
Huh?
Died, not. Ten 8 minutes. 10 8 23.
10, 8,
23.
23. Who died?
Respondent number 4 million. Page 9, paragraph 2 million. Now I. Opposite party number Milan, page 8, opposite party number 1 and 2 Milan, their son and daughter.
Okay, Mr. A. Rashid, the counsel for the applicant submits that respondent number 4 had died on 10/8/2023, leaving behind the
Son and daughter.
leaving behind two legal representatives whose who are arrayed as opposite parties to this application. Expiration notice. Let's see. This application has been filed on 18/10/2023. And therefore it appears this application under Order 22, Rule 2 CPC appears to be on time.
And this without and without entities.
You'll have to correct it. It can't be under 2. Substitution will always be under 4. Substitution cannot be under 2. That's why when I was writing in the order 2, it struck my mind and then saw it.
You would have seen that.
You read 2, what does it say? The court will just record it and proceed against the other defendants. It doesn't say about substitution. You do the correction before the registry, because the central registry has to be corrected. Just say on the prayer made by Mr. A. Rashid, counsel for the applicant, is permitted to make necessary correction of the provision of law in the cost title. First, thereafter, so it will be AOJ, civil appeal section, AOJ civil appeal section. And thereafter, matter will be distributed before the court again. It should be for
By tomorrow.
anything you do. We'll release this file today. I'm not saying anything because it has to go to this section and you'll have to do it. We'll release the file. You can go tomorrow.
Forty-two.
I have for substitution, Your Worship, respondent number 1E, I number 3616.
Who has died?
Respondent number 1E.
1E
Yes, sir.
died on
5/10/2023.
5/10. So, who are the legal representatives?
Son and husband.
They all are parties here.
They are not in party.
Okay. Mr.
A. Hussain, Your Worship.
A. Hussain and counsel for the applicant. And Mr. M.
Hussain.
M. Hussain, huh? M. Hussain and counsel for the opposite party numbers.
Except one C and E, all respondents.
Except one C and E.
Yes.
Who appears for all the respondents except one within bracket C and one within bracket E. Next,
Another IA is here. Another IA is here.
for
Substitution, 1C.
this is for 1C.
This is for 1E.
Okay. We'll have to pass separate orders, not common. It is something that it is submitted by the Learned Counsel for the applicant that on 5/2/2023,
5/10, Your Worship.
5/10, okay,
Yes.
5/10/2023, the respondent number 1 within bracket E had expired. And therefore, this application for substitution under Order 22 Rule 4 CPC. Next, issue notice on the parties sought to be implicated whose names and particulars have been provided in the cause title. As it is in paragraph 2 of this application. Next paragraph. Notice is made returnable. No, same time. Notice is made returnable on so and so. Next paragraph, the applicant shall text it within 2 days for service of notice on the opposite parties by registered post with AD. Next paragraph, the Learned Counsel for the applicant is at liberty to correct postal receipt number, track report, list on so and so. Same order for 40 in IA Civil 3619. 3619. 1C has died on
17/10.
17/10/2023. Same order. Okay, take steps within 2 days.
Most of it.
43. This is bundle of delay petition lawsuit, first time lawsuit for investment compensation by the climate lawsuit, 138 days lawsuit.
138 days. Okay. Mr. A.R. Agarwala, 138 days delay. Filing the connected appeal. Notice take steps within 2 days. 46.
I'm praying on behalf of MS M. Chaudhary. He is not well today. So that I may be adjourned for that.
Just a moment. Yes, Mr. Chauhan.
Sir, the member, my lord, committed gross, my lord,
Okay, then we'll have to adjourn it if she's ill. If she's sick,
adopting my lord, said.
no, that's okay, but she's absent. She's unwell. Huh? Both sides are represented. It is submitted on behalf of the respondent number one that the council holding a brief is indisposed. Accordingly, matter stands adjourned today. List on 24/1/2024. Forty-seven. Yes, Mr. Khan.
Herein also, your lordship, the petitioner, the respondent, he filed a petition under section 24 of the Hindu Marriage Act, your lordship. And in that petition, your lordship, the order case 1, case 30, your lordship, kindly have it. Maintenance has been granted, your lordship, altogether 15,500 to the respondent and has 2 minor side.
Same question will arise here also.
But herein, your lordship, I am only for the quantum, your lordship. The petitioner, he has huge liabilities, your lordship. But considering that, your lordship.
But you'll have to address us on that.
No document has been annexed, showing that.
That's okay. The question is now whether this revision would be maintainable or it would be an appeal against the order of under section 24.
Could be an appeal.
Is it after the vacation? January 19th.
But he may be directed to regularly pay the mallet amount. He has not paid.
No, for that you will have to enforce. And if there is a, what do you call, I don't find that there is a interim order which was there.
Order was passed by the land court below, my lord.
No, I understand. But you see, I cannot permit this court to become an executing agency. So you have to take your own.
Under the guise of this pendency,
No.
taking some.
You see, if there is a stay, then I can understand. If there is no stay, why should I hear that? Correct. If I have granted stay, then I'll definitely hear you. But if I have not stayed it, why should I subject myself to hearing? Correct. Both sides are represented. A question of law arises in this case as to whether against the order of maintenance, an appeal would lie or a revision would be maintainable. First of all, Mr. A.M. Khan, counsel for the appellant, sorry, petitioner, and Mr. P.G. Saikia, counsel for the respondent, shall address the court on the said point. List on 19/1/2023. 51. Oh, 70. Okay, yes, I remember now. Yes. You have to speak loudly. I can't hear you. Okay, we accept your statement because we'll be closing it. We accept your statement. Heard Miss B. Jain, counsel for the petitioner. Upon instructions, she has submitted that this matrimonial dispute between the parties have been settled outside the court and an agreement has been drawn up. Agreement dated 16/12/2023 has been drawn up. And accordingly, she has instructions not to press this matter. Post prayer is allowed. This matter stands closed on withdrawal. Okay. This 50, this is 51. Just say that none of on call for the respondent. Respondent. 52.
The name of the sole respondent is shown in the clause list.
Pardon me?
It's the R proponents.
52. Ah, yes.
Pattern ask for admission within the appearance complete.
Oh, yes, appeared. Okay. But Mr. R. Sharma, counsel for the petitioner. uh, From the, he has pointed out that the respondent has entered appearance by filing Vakalatnama and the name of the learned counsel appears in the cause list. Full stop. Huh. Yes. Listed for admission. Okay, Mr. Arfukan. Arfukan for respondent. So the case is ready as regards service. Accordingly, list the matter in the admission column after the ensuing winter vacation. You just make a prayer, what do you call it? Make a mention if it is not listed. Okay, interim order past release stands extended till the next date of listing. Make a mention if it is not listed.
53.
53.
If we are in this matter,
You have to button up your coat.
sorry,
No, it's okay.
I'm not.
No, it's okay. No, it's okay.
Not I have impugned an order under order 7 rule 11 by which my application by 7/11 was rejected.
Okay, yes.
But Lordship, I pray for 2 weeks time to file in the affidavit manner.
Okay, you should have told him he's staying for the entire day today. If you, no, you see, permission is something else, but since he appears to be from auto station,
Delete for this matter.
since he's coming from auto station, he appears to be a new face, so that's why I'm saying it. Lawyers have come and it saves so much of trouble to everyone. You choose a date when you are coming next. Tell us.
Whatever date, my lord is fixing for hearing, if 22nd January is possible. If see, my lord has given few dates on 22nd January. Or if it has to be somewhere in February, then whatever date.
No, you choose a date. Since you are from auto station, you are giving you that liberty. Choose a date.
22nd.
22nd. Okay. If it is 22nd January, your affidavit shall be filed within 18th.
Yes, Lordship.
Correct?
Yes, Lordship.
You take his email number and send it.
Yes, Lordship. Send
Huh,
a soft copy.
Okay.
The interim order to continue.
Oh, okay. Mr. A. Srivastav, counsel for the petitioner. Most of Ms. R. Barwar and counsel for the respondent. Prays for some time to file affidavit in opposition in the matter. Most of prayer is allowed. Affidavit in opposition we filed within 18/1/2024 with soft copy to the counsel for the petitioner. List the matter on 22/1/2024. Give her your email number. No, it's okay. I don't take an offense of it, but it's my habit to keep on talking.
I was not aware of the decorum which is maintained here. The parent code, that's not in requirement. I'll be careful.
No, not that. You see, his intention is not to what you call not to say anything adverse personally. It's just by habit that I what do you call I put it in that manner. You will find here, I'll show you something, which will tell you why. Just tell you something. Uh, Page 870, last flag. It starts from left side down below. 870, I flagged it.
Have 455 pages.
No, that page is there. I flagged it. Second flag. Second flag. Rule 870,
The rule itself, just.
correct. I flagged it for you.
Very well. Yes, madam. Eight
Yeah,
seventy.
down below. You did not read it just for yourself. 870. Then next para is 1, 2, 3, 4. Next page. Look at 4. No, same page.
Same page.
Huh.
Very well. Very well. Thank you.
It's only that
No, I totally understand.
because this is how we have been groomed. So I have a what you call infallible habit of making comments immediately. Not with them. It's not to what you call demean your don't take it as it's
No, I'm not taking. My colleague
huh.
actually told me that the honorable judge may point out if the trousers are not of the same color. I looked at mine and I was sure that everything is fine.
It's just my habit, but it's not to demean you or to say anything adverse to you. Yeah, it's
Thank you.
just my habit. 53. Oh, this is 53. Oh, okay. 54. No, 54.
So it's not dated 15/12. Neither AD card nor another notice received as well. So this is the fact.
It has been 112. What about Dusty?
Taken steps in both ways, registered as well as.
You have taken. But then if you have taken Dusty, you'll have to file an affidavit. Nobody else is coming to file your affidavit. Correct. Okay. Miss R. Saha, counsel for the petitioner, shall inform the court about the as to whether notice could be served by way of Dusty mode. Next para. In view of the office note dated 18/12/2023, comma, let the matter be listed before the Laozima court after ensuing winter vacation for passing appropriate orders with regard to service of notice on the respondent by registered post. Thereafter, the matter be listed before the court. Okay, interim order passed release stands extended till the next date of listing. Okay, 49, who made the prayer for adjournment? You made, okay. 49, both sides are represented on the prayer made by Mr.
G Imtiaz, appearing for Mr. A. Sattar.
J.
G Imtiaz.
G. Imtiaz, I'm sorry, Mr. G. Imtiaz, counsel for the respondent. The matter stands adjourned today. What is the matter about?
My lord, not.
Okay, what is this matter?
Lordship, I find the suit and the respondent also filed the suit. The respondent filed the suit earlier to me. And thereafter, they filed an application under section 10 to stay the suit. That was allowed. Against that order, I have prepared this.
Okay. List on. Make it 19/1/2024. The interim order passed release stands extended till the next date of listing. Okay.
Obliged.
Item 32.
Yes, Mr. Khan, item 32. You obtain instructions.
Right. Not of-
You listed after vacation, then you give a date.
Lordship, there is an order that we verify, Lordship. There is an order for
No,
attachment.
no, you see, everything we can't bulldoze, correct? Law must be given some space so that you can get instructions. We have told what we are intending, correct? Mr. A.M. Khanlan, counsel for the petitioner, as well as Mr. G.J. Sharma, counsel for the respondent, are present. On the prayer made by the counsel for the no, you have to say that the counsel of both sides will address the court on the maintainability of this application under Article 227 of the Constitution of India. As the order granting maintenance is otherwise amenable to appellate jurisdiction. Correct?
Review jurisdiction. The review.
Appellate. Appellate as well as review jurisdiction. And moreover, the alternative remedies which is prescribed for revisiting the ex parte order.
So-called expert. So-called expert. So-called expert.
Achha, so-called ex parte order, correct. So-called ex parte order. Next para. The learned counsel for the respondent expresses urgency in the matter by submitting that pursuant to order dated 22/2/2023 passed by this court staying the operation of the impugned order, the respondent has not been paying any maintenance to the respondent in terms of the any maintenance to the opposite party, sorry, to the respondent. Full stop. Next para. On the next date of listing, the learned counsel for the petitioner shall also the counsel of both sides shall apprise the court about the of the area maintenance which is required to be received by the respondent. Full stop. Next, both sides are put to notice that the matter shall not be adjourned on the next date of listing, list on 5/1/2024.
Lordship, any maintenance will be incorrect, Lordship. They are paying 7,500. Under order dated 25/2/2022, they are not paying maintenance.
Okay, he's only paying maintenance in 125 proceedings.
125 they are paying. In the divorce case, Lordship, I filed a.
It's
in this
okay,
case-
because that was is paying maintenance, not under, not what you call maintenance under the in the divorce proceedings. Okay.
Obliged.
Oh, yes, your matter, Mrs. Paul. Yes.
Actually, the London council is not available as per the.
Oh. Okay, on the prayer made by the land, both sides are represented on the prayer made by the land council for the appellant. Matter stands reluctantly adjourned today. Full stop. Let this matter be listed on 9/1/2023 and 24 in the top of the list. So matter would not be adjourned on the next date of listing.